about today's Supreme Court rulings. So this morning, we had a big ruling from the Supreme Court. In a splintered 4-1-4 decision, the court's four liberals, along with Chief Justice John Roberts, struck down a Louisiana law regulating abortion as creating an illegal undue burden on access to abortion. But four of the court's conservatives, along with Chief Justice John Roberts, also weakened the standard that the court will apply to abortion going forward. In his ruling, Roberts managed to leave both sides of the court, liberal and conservative, moderately unhappy. His opinion makes it clear that he was ruling against the restrictions in this case only because they resembled a different set of state law restrictions that the Supreme Court found unconstitutional 4 years ago. So, for some insights on what's going on here on today's ruling, we are joined by Leah Litman, assistant professor at the University of Michigan School of Law and co-host of the Strict Scrutiny podcast, and Chris Geidner, senior advisor for law and policy at the Justice Collaborative, who has covered the past decade of big Supreme Court rulings on major issues. So, Professor Litman, if we may start with you, give us some context. What happened today?
So the Supreme Court invalidated Louisiana's admitting privileges as a requirement. That requirement required all abortion providers to obtain admitting privileges at a hospital within 30 miles of where an abortion provider performed abortions. If that requirement sounds familiar, it's because the Supreme Court in 2016 invalidated the same admitting privileges requirement when Justice Kennedy was on the court and Texas enacted it. So today, the Supreme Court, by the 5-4 vote breakdown that you just gave, said Louisiana also can't have an admitting privileges requirement.
So abortion rights cases, Chris, are always among the court's more anticipated opinions. What made today's opinion even more anticipated than usual?
Yeah, I think part of it was because of what Leah had just described, the fact that this was a situation in which basically the Supreme Court ruled in Whole Women's Health, and then Louisiana was like, well, are you sure? We had the change in the court as to who was on the makeup of the court. We had the addition of Justice Kavanaugh, and the question was between the addition of him and Justice Gorsuch, like, would it matter? Would it matter that this was the same law? For both of the people who were added to the court by President Trump, the answer was it didn't matter that they had decided this 4 years ago. And it came down to this 4-1-4 ruling with the Chief Justice saying pretty narrow, very narrowly, in a way that, as you sort of alluded to, kept everybody unhappy with him today, that this law is the same as the law that we struck down before. And for that reason, this law is also unconstitutional.
So much of this depends on, I mean, as is always the case, especially in the abortion context with the cases that came before. Professor Litman, can you kind of walk us up to like how we got here and exactly what this is modifying or scaling back?
Sure. So as many people probably know, Roe versus Wade is the major 1970s era Supreme Court decision that said women have a constitutional right to access abortion. After that decision, the Supreme Court relied on Roe versus Wade to invalidate a host of laws that restricted access to abortion. Before President Trump promised to appoint nominees to the Supreme Court to overrule Roe, previous presidents did as well. And after some of those presidents got several nominees, the Supreme Court was asked to overrule Roe versus Wade in a 1992 case, Planned Parenthood versus Casey. In that decision, by a bare majority, 5-4, the Supreme Court said they were not going to overrule Roe versus Wade. However, a narrow subset of those 5 justices said while they would retain the core of the Roe right to to an abortion, they would modify the legal standard that governed abortion restrictions. Instead of abortion restrictions being subject to a very demanding legal test, strict scrutiny, they would instead be subject to the undue burden legal standard, which is much more forgiving and lenient toward the states. And as evidence of that, Casey upheld 3 of the 4 abortion restrictions that were challenged. After that decision, critics of abortion and people who wanted to restrict abortion thought the strategy was, well, let's regulate abortion out of existence, right? Not straight up criminalize it, but just make it more difficult to obtain. And some of those restrictions would be constitutional under the undue burden test. Fast forward to 2016, the Hellerstedt decision that we have been discussing, that involved one of these efforts to basically regulate abortion out of existence. So the Texas law contained not only an admitting privileges requirement, but also an ambulatory surgical center requirement. And the combination of the two would have reduced the number of clinics in Texas from 40 to 7, all located in major metropolitan areas. And the Court of Appeals that upheld it said, well, we're not going to look into whether the law actually advances women's health and safety. And even though it imposes all of these burdens, by making almost 1 million women live almost 150 miles or more from an abortion clinic, that's not significant enough to constitute an undue burden. In Hellerstedt, the Supreme Court says, okay, if the undue burden test means anything, right, if Roe is to remain a reality, then that law constitutes an undue burden, and we will ask whether a law actually advances women's health and safety. So this case was both a challenge to the legal standard in Whole Women's Health versus Hellerstedt, and also just a kind of floating prospect of like, how willing is the court going to be to quickly overrule all of these precedents on abortion? And I think we got different answers to those 2 questions.
Yeah, I wanted to ask you about different answers, especially for like folks who are listening to this who are totally confused by how the math of having 4 people over here and 4 people over here and 1 person who is really with neither of those groups creates any kind of majority opinion. Can you explain like the lack of clear majority and what it means moving forward?
Yeah, so I think it was Justice William Brennan said the most important rule on the Supreme Court is the ability to count to 5. And so if you have 5 for an outcome, right, you win, right? You get the result you wanted. However, if there aren't 5 justices joining the same opinion, then there is a task of determining which opinion is controlling. Here you had the 4 liberal justices joining Justice Breyer, who authored the opinion in Whole Women's Health versus Hellerstedt invalidating the Texas admitting privileges requirement, and they would have stuck with the legal standard that Hellerstedt announced applying Casey, Justice Breyer basically saying, like, I said what I said and I meant it. And then you have the Chief Justice writing separately to say, look, I'll stick with the outcome. In Hellerstedt, this admitting privileges requirement is unconstitutional, but I don't agree with the reasoning, and I'm certainly not going to apply it in future cases that involve restrictions on abortion that the Supreme Court has not already held invalid. Because his vote was necessary to the result, the outcome of Louisiana's admitting privileges requirement being unconstitutional, then you have to decide, well, which opinion is narrower? And I think a lot of people would say the Chief Justice's opinion is narrower in the sense that it would invalidate fewer laws, right? It was for that reason that in Casey, the justices who said, we're sticking with Roe, but diluting the legal standard, their opinion was also controlling because it would invalidate fewer laws.
Got it. So concretely on the ground for people making policy, making decisions, worried about this issue going forward, what's the outcome on the ground?
I think for Louisiana women, it's great. This law would have closed 2 of the 3 clinics in the state. It's not going to do so. That is a huge win. And I don't mean to understate the significance of that victory in any respect. But there are a bunch of challenges to other abortion restrictions that are currently playing out in the lower courts. You have challenges to the so-called non-discrimination provisions that prohibit abortion on the basis of race, sex, disability. You also have bans on common methods of second trimester abortions. So for example, bans on the D&E procedure. You have bans on abortion after 20 weeks of pregnancy. And none of those laws has a Supreme Court directly invalidated. And so to those laws, the Chief Justice has signaled to the lower courts, I'm okay with you applying a more lenient legal standard that might allow you to uphold those laws.
Got it. So This is a question for both of you. There were a lot of dissents. I think I saw a joke on Twitter. Somebody said everybody wants to write a blog post today. Everybody wrote a dissenting opinion. I would love to hear from Chris and from Professor Litman on like what jumped out to you in these 4 separate dissents, all authored by conservative male justices. What signals and seeds do we find in there, or like outright statements do we find in there of how those justices will approach these issues going forward? And what were some of your top moments from those pieces of writing?
I mean, honestly, like I'll speak as little as possible. The men spoke plenty today. I think that the important thing here is that there was not an opinion today by a woman. That none of the women on the court wrote today, and it's interesting that this is now the second time in a row that the liberals have given over the majority to Justice Breyer to write. And it wasn't a majority today, it was the plurality. But I think that what we have here is truly, and if you had 2 worlds today of like a liberal Twitter and a conservative Twitter, the only thing that's agreed upon is that John Roberts is a sneaky bad man, and how he gets there is different depending on which silo you're in. But I mean, I think we basically saw from the dissenters is basically 4 people very mad that there is this long-standing effort to restrict abortion rights, and now they've got 5 guys who are willing to do it, and why aren't you with us? And I think it was literally like we're all gonna write to let you know how disappointed we are in you. And yet at the same time, as Leah's already made clear, like Chief Justice Roberts wasn't like declaring his love of choice today. He was basically saying, wow, Louisiana, I can't believe you put me in this position. It was sort of like his Trump decisions where he's like, I don't want to rule this way, but like, can't you do this right? And I think that the conservatives were very upset that he even was willing to do that.
That's actually a great question that I want to get into, is sort of like analyzing the Roberts role. He's utilized the court's current structure to become this term the de facto swing justice, and perhaps we see the roots of that in prior terms. But how have his swing decisions sort of helped or hurt jurisprudence that he was expected to favor from the conservative side, or that liberals would have wanted him to favor?
Yeah, I think that Chief Justice Roberts, this is his term. He's the most powerful person in the country, arguably in the world. And he's not only the Chief Justice, he's not only the middle vote, he's not only the swing justice. Like he really is on all of those measures the person who matters. And I think it's interesting if you look at the Title VII decision, if you look at the DACA decision, and if you look at today, they're all very different decisions as to what he's doing. In the Title VII decision, he really was a part of like, this is the law, it's over here, and that's the way it's going to be. In the DACA decision, it was this sort of Trump area where like, the truth is, like, I think politically, everybody agreed with his decision, even if they didn't like it. Like, nobody wanted this to be DACA to be the big political issue this year. And he sort of, in a way, did the conservatives a solid by taking it off the table. And now this one is the opposite. This made everybody mad. And so I think he is very much an institutionalist, but he's also a conservative. And the Trump era, I think, has really drawn his institutionalism to the fore. But he's also making it clear in a lot of these rulings, in the census ruling, in the DACA ruling, and then definitely today, that like, this is not some like he's not becoming like David Souter. Like, he isn't becoming a left justice. He's not moving there. This is about the moment, and he is making clear where the ideology will take him in the future.
Professor Litman, I see you nodding. Do you want to jump in on that?
I completely agree with Chris's assessment. I think it would be wild to think of the Chief Justice as, some kind of like swing justice or even wobbly liberal. The cases that Chris was mentioning, the DACA case or the census case from last term, in some ways were very conservative in the legal principles they adopted. They were saying, I am going to embrace strong judicial review of administrative agencies, right? And the skepticism about administrative agencies, having too much power and their power running amok is very much a core tenet of conservative legal views. So it's not like he is embracing progressive legal principles to reach these results. Here too, in June Medical, in some ways he gave the conservative legal movement a huge win. You already see people on Twitter, whether it's Senator Josh Hawley or other people, using this decision, as they did with others, as an occasion to get their base whipped up about the re-election prospects for President Trump in 2020 and the need to appoint more conservative justices. And he staved off a huge progressive backlash against the court on this issue, on DACA as well, again, while laying the groundwork to let states enact more restrictive abortion laws in the future, maybe not in an election year, and maybe not laws that the court has already invalidated.
Yeah, the context of the election year seems relevant. Are there any implications beyond this area of subject matter from today's decision? Does it go beyond the abortion context?
So part of the decision goes beyond the abortion context in that the court rejected the state's argument that the abortion providers and clinics didn't have standing. Had the court adopted that argument, that would have broadly refashioned the law about who can challenge laws in federal court. And you had just three justices, Justice Thomas, Justice Alito, and Justice Gorsuch, expressing some sympathy to the plaintiff's position. And so I think that decision, staved off reverberations in other areas. It's also possible that the court, or rather that the Chief Justice's strong embrace and paean to stare decisis will have implications beyond abortion to other contexts. Though, I'm not entirely sure about that, given his skill and ability to distinguish cases whose results he does not like.
Well, and the only back to that I would say is the idea that he did cite in his concurrence the case of Bobby James Moore, who was a death penalty case out of Texas. And that was a situation where, like this, he had been in the dissent initially. And then the case went back to Texas, and it had to do with mental capacity. And he basically, the Texas Court of Criminal Appeals again decided against Bobby James Moore, and the case came back to the Supreme Court. And that time the Chief Justice was like, it sort of is this idea, where you get John Roberts to join the liberals a lot of the times is when the court has said something, and even if he didn't agree with it, it goes to the Trump administration, it goes to a state, it goes to a lower court, and they still don't implement it. And he's sort of like, guys, what are you doing? We said what it is, and that's what he did in that case too. So I don't think it's even necessarily stare decisis in the way that we talk about protecting old precedents. It's an actual are you listening to what we said last month?
Got it. All right. So last question, because I know you both know this off the top of your heads. And so there may be folks listening who want to know, what do we have left coming up in the term? There's still a lot left to hear about. What can we be looking forward to?
Basically all of the cases that were argued in May, and one of the cases that was argued earlier. So we're still waiting to hear, for example, about all of the cases involving presidential immunity, whether the DA grand jury subpoena from New York can be enforced against the president's financial institutions. Same thing with the congressional subpoenas. We're also waiting to hear about the Affordable Care Act's contraception mandate, and whether that law will be narrowed and restrict access to contraception. We're also waiting to hear about religious exemptions from non-discrimination statutes. So whether if an individual has an objection to applying a non-discrimination provision, whether they can opt out of it. We're also waiting to hear about the constitutionality of Montana's limitations on school funding. We're waiting to hear about whether the state of Oklahoma successfully devoured an Indian reservation by not respecting their treaty rights. We're waiting to hear about a bunch of other cases as well.
Faithless electors. Don't forget the Electoral College.
That's going to be a very exciting couple of weeks.
Yeah, well, and we don't know. That's the other question is we don't know. Like traditionally, the court would be ending by tomorrow at the absolute latest with all of its decisions. There were like rumors over the weekend that we might be getting like 7 decisions today and 6 tomorrow, and we got 3. So that means there are still 10 left, 9 issues. And so it would be shocking if we don't go into July, which will be the first time I think in more than a decade that's happened.
Well, 2020 in this, as in all things, is surprising and extraordinary. So I want to thank you both. Thanks, Professor Litman. Thanks, Chris Geidner, for being with us. We are going to be looking forward to talking with you both again, I hope, about the rulings yet to come. For those of you listening to the briefing, you can join us again tomorrow at noon Eastern time when we're going to be talking with Representative Rashida Tlaib about the Uplifting Local Communities Act. Hope to see you there. I'm Emily Galvan Almanza.